from rule of law to the rule of power. And the context is obviously based on the fact that we have a situation coming from Gaza and up to the situation where we foresee where things are going in international law at the moment. Uh, you have introduced me, but I would like to also inform the worthy participants about the work that I have been doing, which is the intersection of international law and the Quranic covenants. The work that highlights that how Quran acts as a covenant between Allah and each one of us as a believer, and there are frameworks in the Quran, the structure of the Quran, which tells us that how there are sets of multiple and dozens of personal covenants that Allah has with each of the believer. And when we apply the modern law of contract to these covenants, we identify very clearly the legal features and that direct linkages that we have. We call them in our work the covenants in the Quran itself. So the structure of the verses identifies that. In the work relating to Quranic covenants, and for that we have set up a Quran Covenant Research Center as well in Islamabad, which is established within the premises of the Research Society of International Law, another think tank that has been there for last 30 years that I established and worked on. And then, in addition to the covenants in the Quran that we might discuss at some later presentation, we also identify that there are covenants under the Quran or pursuant to the Quran, because the word misak and akud in the Quran covers not only personal agreements that we have in everyday life with people, the commercial agreements, the letters of appointments, the engagement terms, the all other agreements that we do on the civil side with each other are covenants and the commercial agreements under the Quran, because we have a duty to uphold them under the Quran, and that's what has been directed to us. And in addition to these private commercial agreements, we also have international treaties. So, treaties, international conventions, international protocols, international agreements, memorandum of understandings, and all kinds of international arrangements that states enter into each other, and particularly the 57 Muslim states have entered within each other and also with other states, are also within the definition of akud and misak, and therefore it is a duty that we need to uphold them, and that's a duty that the Quran tells us to ensure. And the third category is the legislative covenants, which basically means the laws of the state. Every law, every statute in a state is basically a social contract with the state and the individual. That's how it qualifies to be referred to as Misak and Akud pursuant to Quran, and upholding the law of the land, upholding an international treaty, upholding an international agreement, private agreement, are all fulfillment of the mandate of the Quran directly. So hence they are covenants under the Quran. Now, coming to international treaties that Muslim states have ratified, there are thousands of them. And if any one of you were to go to the UN Treaty Series website, you will be surprised to find out that over a million treaties have been documented in this series amongst various states, and all of them are part of the UN Treaty Series reservoir. Now, these treaties, and quite a few of them, are the ones to which Muslim states are parties. So, 57 Muslim states are parties to most of these multilateral conventions and bilateral treaties that regulate each and every aspect of statecraft with each other and amongst each other. So, whether it is international covenant relating to right to use airspace, or whether it is International Maritime Organization framework, whether it is International Atomic Energy Agency framework, whether it is Non-Proliferation Treaty, whether it is Geneva Conventions, whether it is Hague Law, or whether it is climate convention, they are all conventions and they are all fulfillment of definitions of Akud and Misak. And for a Muslim, if you are associated with the implementation aspect of any treaty as a citizen, as a public servant, as part of the government, then there is a duty that you have to perform pursuant to that. Now, having said that, when we talk about the rule of law and whether in the recent events that we have witnessed in the Middle East in particular, particularly keeping in view the US and Israeli attack on Iran, we find that the rule of power is beginning to take over. But at the same time, I, as an international law person with interest in the Quranic emphasis on covenants, I am of the view that the rule book of law stays the same. The normative principles have not been destroyed. In fact, they have been strengthened by virtue of the fact that everyone is critical of US and Israeli attacks on Iran as lacking legal justification under international law. And this is the view adopted by over 100 international lawyers in the United States who have written a formal letter identifying as to why and how this attack violates international law and undermines rule of law. And although it has been done by resorting to brute force, yet at the same time, it is not in accordance with the normative principle or the rule book, as we may call it. In addition to that, the American Society of International Law, which is also an international organization which is for the purposes of international law capacity building, undertakes various functions throughout the world, that also issued a formal opinion that the right to use self defense in Iran is not justifiable as no imminent attack was identified. So, here in this episode, one notices that although part of US administration thinks that it can resort to power, but the prevailing sentiment or a different sentiment within the same administration is to the contrary, which further strengthens that the global order, global rule of law has not been undermined as much as it may appear to be. It is true that United Nations Security Council may not be performing to its full potential to prevent the resort to use of force by such powerful countries. Now, but that means that the organization, which has a duty to enforce the book or the rule book, is paralyzed for a time being. But it does not mean that the rule book itself stands evaporated or it stands completely nullified. It rather, as I said, stands emphasized because this rule book, these international law frameworks continue to be the reference points pursuant to which US is being pointed at and Israel is being criticized not only by the 57 Muslim countries but also European countries, Council of Europe, UK and Canada and all other countries in the world. Not even a single country has welcomed, and that is one clear reason you sense that the allies of the NATO have chosen not to join this for the want of the fact that it does not have sufficient legal reasoning or just cause justifying the resort to use of force. At the same time, when Iran decided to attack various GCC countries, now that is where yet another rule of law framework emerges. The rule of law is that you will not attack a civilian infrastructure. Attack on civilian infrastructure by Iran also violates the rule book of international law, which talks about that if you are choosing to attack a certain venue or a certain target, then it should only be done if it is put to a military use or it is a target which is being utilized. So, in that sense, attacking on military bases selectively could be legitimate targeting under the rule book of international law, but at the same time attacking refineries, attacking hotels, attacking airports, attacking any other civilian infrastructure and data banks should be viewed as being in violation of international law. And that is how it has been viewed by the countries in their entirety. The GCC countries have also pointed out very clearly that they have no intention to have belligerent relations with Iran. And they have said so time and again through their press statements, through their speeches, and through their formal utterances. We here in these circumstances create a distinction between what can be called as legal neutrality versus political neutrality, because legally the neutrality has been compromised by virtue of status of force agreements that these countries have with the United States, allowing some of part of the territories to be used as a military base. But political neutrality means that today these countries are making it very clear to Iran that they have no intention to attack it, and therefore they should be spared, and neither any attack should be aimed against them. So there's a distinction between the legal neutrality versus a political neutrality. Now, having said that, the next situation that arose was the blockade situation, where Iran initially undertook blockade of Strait of Hormuz, and then blockade was further blockaded by the United States. And we continue to hear overlapping, conflicting factual positions on that. From a rule book of law, people have been anchoring their position, their criticism, again on the existing rule book. And that rule book title is Law of the Sea Convention 1982, which talks about the straits will not be prevented or obstructed. There is a freedom of movement through the straits. A lot of countries are archipelagos. A lot of countries have specific geographical restrictions and restraints. And given the fact that straits give natural advantage or disadvantage, therefore the passage must be innocent, however, and as long as the passage is innocent, they will not be prevented. However, given the fact that once there is a situation of an armed conflict under Geneva Conventions, then possibility of blockade can be raised. But once a ceasefire is announced, and that is what Pakistan was making an effort to extract declaration of ceasefire, which would enable then to argue that now the legal position to install a blockade has come to an end. Again, keeping the legal details apart, one is very clear to notice that it is the rule book which is the reference point to make a judgment call with reference to with reference to what they with reference to uh, there's a judgment call with reference to the actions which are being done in that situation. Hello, am I
Yes,
connected? Yes, I think.
yes, you're connected.
Yeah.
Please carry on.
All right. So basically, so that's what the situation is. So while we may feel some frustration at this stage that the powerful can find their own way, my own sense is that the normative rule is strengthening, and there are reasons for that. These rules were not laid down in 1949 with four Geneva Conventions, or they were not laid down in the Hague Conventions for the first time. They represent maturity of civilizations all over the world. All civilizations, whether Chinese civilizations, whether civilization of Egyptian civilization, whether any a civilization, they all talk about upholding the rule of law. They all talk about upholding promises. They all talk about upholding your commitments. And this is a very important aspect of all religions by and large and all civilizations. So the law as it stands represents the civilizational maturity of the human race, where they have arrived at as a consensus that they will not resort to use of force unnecessarily except in self-defense. And this position was then duly reflected in 1945 for the first time in the UN Charter, where everyone agreed we will not attack the other country. We will not use aggression as a mean to acquire territory. And those times, when older times one goes through history, the generals would attack another country, take control by virtue of occupation. That time has come to an end. And after 1945, the UN Charter made it very clear and made it known that all civilizations, all religions have developed this consensus that they will live peacefully and they will address larger issues. And as a human race, they will progress together. And if there is a conflict, it will be sorted out through alternative means, through Pacific settlement framework. So, as I said, while there may be a situation of great tension in our neighborhoods, we should nevertheless continue to maintain this principle that this rule of law will not be displaced so quickly as we think it may. People may be disappointed on the streets, in the offices, and elsewhere that where is the venue one can go and reach out. But I all I see is possibly some alternative venues evolving, such as the Shanghai Corporation, which has not taken off the ground as of now, but it may strengthen itself gradually. Because just a few years ago, China and Russia they came out with a joint declaration on international law, which meant that they wanted to develop their own legal framework in addition to the United Nations system. Or another alternative could be that a regional framework may also take over. So you could develop a regional framework of a group of like minded countries which can come together if they sense there is a threat which is likely to endanger their peace and security. For example, in our neighborhood, on the Indian side, there is a very clear claim that they want to have Akhand Bharat or a greater India, and in that they wish to include Nepal and Bangladesh and Sri Lanka and Pakistan and even Afghanistan. So now, if that is the case, then all these five, six countries become like-minded countries who expect some sort of violation of the UN Charter in respect of their territorial integrity. Similarly, on the in the Middle East, we also hear that Israel talks about Greater Israel framework, and now this is an official, sometimes an officially proclaimed position as well. Again, that means that in Greater Israel, some surrounding countries are likely to be included as part of that claim. Again, this violates the UN Charter of 1945, meaning that again those countries can come together as like-minded countries. So, as I said, any threat which is violative of international law will create its own positive momentum with respect to those who are likely to be affected by it. And that is where I will stop for the time being. And if there are any questions and comments, we can take them on. But my summary and my conclusion would be that disappointments apart, I believe that the rule of law continues because the rule of law, the language of law, and the formulation of law has a tradition, has a history. It is based on international custom. It is based on civilizational values. It is based on uh, the religious doctrines. In all the three Abrahamic religions, there is a very outright, clear emphasis on upholding treaties and contracts. And as long as that is there, I believe the law will not be sidelined so quickly as it appears to be. I thank you.